Good evening, ladies and gentlemen. Can you hear me? Yeah. Great. All right. I'm Mike Smith, Director of the Nebraska State Historical Society. I'd like to welcome you to our program this evening. Thank you for coming on a beautiful fall day. In 1787, the Young American Confederation of the States, as they call themselves, had a convention in Philadelphia, which Catherine Drinker Bowen famously called the Miracle at Philadelphia. That convention was composed entirely of men, entirely of white men, entirely of property owners, entirely of professional people, merchants, and others who had a great deal of economic interest in their young nation. Over the last 200 years, America has struggled to determine who is included in the words they used in the preamble to the Constitution, we the people. Were the we only the people who were writing the Constitution, or do the we include a great many others? Who is in, who is out, who is included, who has been excluded? The Nebraska State Historical Society tonight welcomes you to this inaugural presentation in a series that will explore Nebraska's role in working out who we are in our state and our nation. Over the next 11 months, public programs, community conversations, a special issue of our Nebraska History magazine, an exhibition, and opportunities for citizens to record their stories and reflections will give us a chance to examine our past as we define we the people in our future. All of these events are open to the public free of charge. Funding has been provided in part by the Nebraska Humanities Council and the Nebraska Cultural Endowment, and we thank them. Additional support comes from the Woods Charitable Fund and the Cooper Foundation through the Nebraska State Historical Society Foundation, our partner in what we do for history in Nebraska. We invite you to return for the next program in this series on November 16th, 2010, again at 5:30 p.m. in the evening, when Dr. James Wrightingin of the Pawnee Nation speaks on sovereign Indian nations and the U.S. government. But tonight we're very excited to have a special speaker to inaugurate our series. U.S. District Court Judge Laurie Smith Camp is our presenter. She's a graduate of Stanford University. I should say she grew up in Omaha, attended Stanford University, and came back to Nebraska to attend law school at the University of Nebraska. Early in her career, she was in private practice, but in 1980, she was employed as general counsel for the Nebraska Department of Correctional Services, where she served for 11 years. In 1991, she became chief of the Civil Rights Section for the Nebraska Department of Justice for 4 years, and went on to be Chief Deputy Attorney General for Criminal Matters with the Nebraska Department of Justice from 1995 until her nomination to the federal bench in 2001. She is District Court Justice for the District of Nebraska. Her courtroom is in Omaha, and I think you'll remember that she's been regularly in the news as she exercises what I think almost everybody agrees is an independent spirit and independent thinking, and I think that's very important among all government officials and certainly among the judiciary. Tonight she's going to tell us something about the development of the rights of women, none of whom, as I said, were members of that convention in 1787. Judge Smith Camp.
Thank you very much, Mike. It's a pleasure to be with you here to kick off this series of the Nebraska State Historical Society on civil rights, and I'm happy to see so many receivers here. There's no point in kicking something off if nobody's here to receive, so thank you all for being here. 90 years ago, the 11th Amendment to the United States, 19th Amendment to the United States Constitution was ratified. That amendment did not give women the right to vote. It recognized the right of women to vote and to participate in their government. Just like the 13th Amendment did not give Americans of African descent the right to be free from slavery, it recognized that right. A lot has happened in the last 90 years, and much of it has occurred in the last 50 years with respect to the issues of women's rights and which rights have been recognized. Today, I want to turn the clock back for a ways to try to put the last 50 years in context Then I'm going to touch on some of the changes in the law, both Supreme Court decisions and legislative changes, by weaving that information in with some anecdotes of a typical woman growing up in Nebraska in the baby boom generation. And then finally, I'll ask you to fasten your seatbelts and we'll do our fast forward through the last 50 years, touching on the Supreme Court decisions and the legislation very briefly. This pleasant-looking fellow up here is Cato the Elder. As you can see, we've turned the clock way back to 195 before Common Era, and Cato the Elder was the consul of the Roman Republic. He was the most powerful man in the world at that time. Now, in his era, the right of women to vote was not recognized. The right of women to possess property was not recognized. The right of women to transport themselves from one place to another was not recognized. The right of women to choose what clothes to wear was not recognized. And Cato liked it that way. And he gave a speech that helped his political career in which he spoke out against women's rights. There is a statement in his speech, though, that is very telling and that should be shared to put history in context. He said, "If for one moment you allow women to be your equals, they will forever after be your superiors." Now, Cato was an honorable man, and I'm sure that Cato believed in the truth of what he was saying. But he also knew that his statement would strike fear and terror in the hearts of his friends, Romans, and countrymen. Now we're going to fast forward about 1,800 years to England, London, England, in 1616. This relief is taken from the bronze doors on the U.S. Supreme Court. And on the left, it shows Chief Justice Edward Coke, and on the right is King James. This scene depicts Edward Coke blocking the door to the King's Court and not allowing King James to come in. Edward Coke famously said, "The king is under no man, but he is under God and the law," meaning that the king could not take over the court system. The judiciary was independent of the executive branch. Well, that's very heady stuff. That sounds very inspirational. Chief Justice Coke is also the individual who is largely responsible for compiling what we refer to as the English common law. He took cases, court decisions from across England over hundreds of years, and he wrote them down and compiled them so that law students and lawyers and judges could refer to them. Before that, the law was passed down in England largely through oral history, through the Inns of Court in London, where judges and lawyers taught the law students. One thing to remember about Chief Justice Coke, though, is he was a very ambitious man, a little like Cato, and he chose the cases that he liked. Now, Chief Justice Coke married twice. He married very wealthy women. He stole all of their inheritance, denied them even the income from their inheritance. He beat them, and he also beat his 14-year-old daughter to sell her off into a marriage that she was unwilling to enter into, but it was a marriage that promoted his political career. So when he chose the cases that he liked, he chose cases that said all of a woman's property belongs to her husband, her services and her body belong to her husband, a married woman has no right to enter into contracts, and husbands can beat their wives as long as they use a stick no bigger around than their thumb. This is how we get the rule of thumb. Nevertheless, Edward Coke was a hero among the Puritans and the separatists who came to our shores to colonize this continent, and they brought with them the English common law. Now, not everyone in the colonies agreed with Edward Coke's version of the law. In 1634, Anne Hutchinson was a Protestant minister who was very popular among women, and she also began to gain great popularity among men. She was a threat to the administration of the government there in the Massachusetts colony. She advocated or spoke out in favor of the equality of women and the equality of the races, particularly Indians. She believed that the Indians were very badly treated by the colonists and that it was inexcusable and that there was no spiritual difference between Indians and white people, and there should be no legal difference. In 1638, she was brought to trial in Massachusetts and condemned to banishment and excommunication for heresy. Anne and her followers moved to Rhode Island, where they helped to establish a new government that provided for trial by jury and separation of church and state. In 1643, ironically, she was killed by Indians, who no doubt had many grievances. I'm grateful to these Indians, though, because one member of her family was spared. It was a little girl who had red hair. And the Indians named her Autumn Leaf. I think they considered red hair to be a novelty. They raised her, and when she grew up, she didn't want to leave and go back to the white community, but she did, and she had a large family. I'm descended from Anne Hutchinson, and I inherited the red hair, for better or for worse. So let's turn forward another 150 years to the Enlightenment, the age of reason. Philosophers talked about the rights of man, and republics began to replace monarchies. Women began to ask, what about us? As John Adams was working on the cause of American independence, his wife Abigail told him, don't forget the ladies. We are determined to foment a rebellion. Well, the men did forget the ladies, and there was no rebellion. The French Revolution followed close behind the American Revolution with the motto, liberty, equality, fraternity. Over in England, Mary Wollstonecraft followed the French Revolution, liked some of the things that she heard, and thought that those principles ought to apply to women too. She wrote a seminal treatise on women's rights called The Vindication of the Rights of Woman, but she forgot about the fraternity part of the slogan, and her ideas were not widely accepted. As a footnote, Mary Wollstonecraft was the mother of Mary Shelley, the author of Frankenstein. And some people would say that both Mary Wollstonecraft, who began the women's rights movement, and Mary Shelley created monsters. The women's rights movement in America gained momentum in connection with efforts to abolish slavery. Here we see Harriet Tubman leading slaves to freedom. She said, I freed 1,000 slaves. I could have freed 1,000 more if only they had known that they were slaves. Discussion of human rights inevitably led women to ask again, what about us? The United States women's rights movement gained national attention in 1848 with the Seneca Falls Conference on Women's Rights led by Susan B. Anthony. And it's been pointed out to me that there are a number of men here, and I want to mention that a number of men were very supportive of that convention and the concept of women's rights, and have been over the last 150 years. Certainly Frederick Douglass was. Over in England, John Stuart Mill was. Horace Greeley was. Henry Ward Beecher, excuse me. It was Harriet Beecher Stowe, Henry Ward Beecher. So there were many male advocates of women's rights too, and I don't ever want to imply that there are not. After American slaves were freed, the United States Constitution was amended to recognize the right of citizens to equal protection of the law. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The 15th Amendment, that followed close behind, says, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude." Now, some women read these amendments and thought that the amendments applied to women, who, after all, were persons and citizens. Susan B. Anthony attempted to vote in 1872 and faced criminal charges. She was convicted. Also in 1872, the United States Supreme Court reviewed the case of Myra Bradwell, a woman who had sought admission to the practice of law in Illinois. The Supreme Court found that women had no right to practice law. In a concurring opinion, often cited, one justice said, "The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. The paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator," unquote. Well, when anyone says this is the law of the Creator, it ends the discussion. How do you argue? How do you debate when somebody says God says so? It ends the discussion. During this era, the Industrial Revolution changed American culture and the role of women. The home was no longer the center of industry and education. Men were leaving the house to work in factories and offices, and children were going to public schools to be prepared for the workforce. As women began to be drawn into the labor force, laws were enacted to protect women and children from the hazards of industry, such as long work hours and dangerous conditions. Because women's work hours and conditions were restricted, employers could justify paying them less. During the Industrial Revolution, urban squalor made poverty more concentrated and visible. Women organized through churches and charities to provide relief for families living in urban poverty. The women's groups began to identify alcohol abuse as one cause of poverty, domestic violence, and the neglect of women and children. In this era, saloons were often integrated with gambling and prostitution, so women organized in pursuit of legislation prohibiting the sale of alcohol. At the same time, women were pursuing the right to vote nationwide. Some men feared that if women attained the right to vote in national elections, a constitutional amendment would be adopted prohibiting the sale of alcohol. Consequently, many male voters opposed any constitutional amendment recognizing that right. The 18th Amendment to the United States Constitution, prohibiting the manufacture, sale, or transportation of alcoholic beverages, was adopted in 1919. Opponents of prohibition then appear to have relaxed their opposition to women's right to vote, and that's how we get up to the 19th Amendment to the Constitution that I began with. In 1920, the 19th Amendment was ratified, and the United States and every state was prohibited from abridging the right of women to vote. Some people believed that women's rights had gone as far as they could go. After all, women had the right to vote. Women were a majority of the voting population. Surely whatever they wanted, they would simply enact into law. When World War II came along, women made great strides in industry and the professions. But after World War II, some sociologists, influenced by Freud, concluded that the women's rights movement had gone too far and had been detrimental to women. The home was no longer the center of work, education, or entertainment. These sociologists concluded that women had lost their natural place in society and were trying to fill roles for which they were unfit, causing them to be severely neurotic. This was an era of regression in women's rights. Now, you will see that we're missing one slide that I thought was there, but that's all right. Freud and Cato bear a remarkable resemblance to each other. If you later we'll flip back and forth, but they have the same expression on their face. It's the same brow, it's the same nose. And so I was going to have both of them looking over my shoulder here as I talk, but we'll just have Freud watch while, in horror over here, while I talk about the changes of the last 50 years. And as I mentioned, I'm going to weave together this information in a way that hopefully will make it meaningful to you, I'm going to provide anecdotal information from the life of a typical baby boomer woman growing up in Nebraska. I was born in 1953. My father taught me to read at an early age, and one of the first things that I read was the want ads in the Omaha World Herald, because I wanted to find a job and move out of the house. I liked the Pippi Longstocking books. I thought that she had a good life, and I thought if I found a job, maybe I could live like Pippi Longstocking. I noticed that the ads were divided into men wanted and women wanted. The good jobs were listed under men wanted. Newspaper carriers were wanted, but boys only. When I started school, the social life of children was channeled into scouting. Girl Scouts and Boy Scouts are both wonderful organizations, but they're founded on a little different theory of what boys want to do and should do and what girls want to do and should do. The International Scouting Movement was founded in England by Sir Robert Stevenson Smythe Baden-Powell. He was inspired by Rudyard Kipling's Jungle Book stories, and the Cub Scouts, or Wolf Cubs as they're called in England, were patterned after the wolf pack described by Kipling in the Jungle Book. Now, to quote Kipling, and this is the law of Akela, and Cub Scouts talk about following the law of Akela. Now is the law of the jungle, as old and as true as the sky, and the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law runneth forward and back. The strength of the pack is the wolf, and the strength of the wolf is the pack. Now let's turn to the brownies. I was a brownie. Brownies were named for the characters in a story by British author Juliana Horatia Ewing. The brownies in her story awoke before the family, swept the hearth, lighted the fire, set out the breakfast, tidied the room, weeded the garden, did all the housework, and were never seen. They refused to accept any wages. They did all their work out of love. My father was a lawyer. On Saturdays and during the summer, he took me with him to his office to answer the telephone and to help with some filing. All the lawyers in the office were men and all the secretaries were women, although they were called girls no matter how old they were. His firm represented business owners and handled all kinds of civil matters except divorce. He said most lawyers considered divorce cases to be undesirable, and most judges didn't like to handle divorces. So his firm would handle a divorce only if an existing client, such as a business owner, found himself in need of one. Since the business owners were all men, I wondered who represented the women. Legal forms used in the office for wills and trusts were different depending upon whether they were for a man or a woman. If a woman was the subject of the document, her financial interests generally were placed in the protection of a man. Sometimes my father took me to lunch at a private club called the Omaha Club. As in most private clubs, women were placed in segregated dining rooms over the lunch hour so they would not disturb the serious conversations of the men. When I ate lunch with my father, he could not sit in a dining room where the businessmen ate because I was not allowed to be there. Sometimes he took me to his Lions Club meeting on days when the men were permitted to bring female guests. As with most service clubs through which businessmen engaged in networking, the Lions Club did not admit women. In 1963, Congress enacted the Equal Pay Act, requiring that employers pay equal pay for equal work, regardless of an employee's sex. Of course, at that time, employers weren't required to hire women at all, and in fact, many laws adopted to protect women from harsh working conditions prohibited employers from providing employment opportunities for women. In 1964, Congress enacted a Civil Rights Act, including what is known as Title VII. That act made it unlawful for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. One might assume that in 1964, Congress recognized the right of women to be employed on equal terms with men. Actually, the word sex was added to the bill by a congressman who opposed the Civil Rights Act. All the congressmen who spoke in favor of this amendment adding sex discrimination to the bill, presented their arguments in a humorous context, and all of them voted against the bill. The protections that women enjoy through Title VII of the Civil Rights Act originated as an insult in an attempt to kill the bill. In 1968, the Equal Employment Opportunity Commission said that employers violate Title VII if they advertise employment opportunities in sex-segregated want ads. 5 years later, the Supreme Court held that a newspaper does not have a First Amendment right to publish want ads segregated by sex. I graduated from public high school in 1971. At that time, military academies like West Point and Annapolis were closed to women, as were most all of the Ivy League schools. So I applied to Stanford University. Stanford was founded in 1898 by Leland and Jane Stanford to provide educational opportunities for men and women. In the university's early days, when the admission standards for men and women were equal, significantly more women were being admitted to Stanford than men. And admittedly, that was partly because so many of the other schools were closed to women. Mrs. Stanford was worried. She knew that the prestige of the school would be destroyed if there were more women students than men. So she placed a quota on the admission of women not to exceed 40%. The trustees of the school improved on the plan by limiting the quota to 33%. Even in a coeducational college like Stanford, some programs were available only to men. When the student body voted on matters of concern to the students, women were outnumbered 2-1, and that fact was apparent in the vote. In 1972, Congress enacted Title IX of the Education Amendments to the Civil Rights Act, prohibiting sex discrimination in education programs receiving federal funding. It was not until 1996 that the Supreme Court recognized that separate but equal education for women is not equal, and male-only admissions policies in state-supported schools violates the 14th Amendment's guarantee of equal protection. In 1974, I returned to Nebraska to attend law school. In 1975, after my first year in law school, I was married. It was possible for me to pursue an education and a career after I was married because in 1965, the Supreme Court recognized the constitutional right of privacy includes the right of a married woman to use contraceptives. Some people think that the constitutional right of privacy is something that was made up by the Supreme Court in the 1970s, and that's not the case. It goes back decades earlier than this right that was recognized in the 60s to the use of contraceptive. The clinic where I received health care informed me that my account must be changed to my husband's name and the bill sent to him because the clinic would not maintain an account in the name of a married woman. In 1976, Nebraska was the first state in the Union to recognize that rape within marriage is a crime. And John has just researched this and provided me with some legislative history on that subject that I look forward to reading. In 1981, the Supreme Court of the United States held that state laws designating the husband head and master with unilateral control of property owned jointly with his wife are not valid. That was 1981. In 1977, I graduated from law school. Most law firms in Nebraska employed fewer than 15 people, so they were not governed by Title VII. Some firms frankly stated that they would never hire a woman. The senior partner in one firm that did grant me an interview told me that if I was hired, I would be required to work in a back office and have no contact with clients because the clients would not accept a woman lawyer. He also informed me that if any male lawyer was hired after me, the male lawyer would always have seniority over me. I began my legal career as in-house counsel in the largest bank in Lincoln. It was subject to Title VII. It was also subject to other laws enacted by Congress in 1974, recognizing the right of women to receive credit and housing on an equal basis with men. Part of my job was to help the bank revise its forms and its policies concerning consumer credit and mortgage loans so that the bank would no longer discriminate against women seeking credit. The bank had a few female officers, but those women didn't supervise any men. At the monthly customer appreciation days, the women in the bank, including the female officers, were required to serve coffee and cookies, and the men were not. I saw limited opportunity there, and I moved to Kansas. It's not that I don't like serving coffee and cookies, but I moved to Kansas, and I obtained a job in a firm that specialized in civil litigation. The trial experience was wonderful, but I had no prospect for promotion to a partnership position. It was not until 1984 that the Supreme Court ruled that law firms may not discriminate on the basis of sex when determining who should be promoted to a partnership position. I returned to Nebraska and I began a career in government practice and law enforcement. From 1980 to 1991, I served as general counsel for the Nebraska Department of Correctional Services. At the time that I joined the department, women were not permitted to work inside the correctional institutions housing male inmates. Women did work in positions outside the wall, such as visitation, but they were not eligible for promotions. Women working for the department threatened to sue for equal employment opportunity. Men working for the department threatened to sue if the women received equal pay but did not perform work that was as difficult or as dangerous as the work that the men performed. Inmates threatened to sue if they were subjected to physical contact with women or visual observation by women in violation of the inmate's privacy. The director of the department designated me to head a task force to find a solution for these issues. The other members of the task force were the wardens of the institutions who didn't want to change anything. One by one, we addressed the issues that were of concern to them. Women would be assaulted by the inmates. Women would engage in sex with the inmates. Women would not be able to shoulder their share of the physical work, particularly in a riot situation. Men would be distracted from their duties by the women and would be overly concerned about protecting the women. Women would not be reliable workers because of their family commitments. Men would not take direction or accept supervision from women. Inmates would not accept supervision or direction from women. The uniforms wouldn't fit, especially if a woman was pregnant. If a woman was pregnant, her unborn child was at risk of assault. Showers and toilets would have to be modified to provide privacy for inmates and staff. That would be expensive, and the privacy for inmates might jeopardize security. I've run out of hands here, as you can see. One by one, we worked our way through these issues, and the staff in every state correctional facility in Nebraska was sexually integrated. Meanwhile, the women sued, the men sued, the inmates sued in a triple class action in federal court. Ultimately, after an appeal to the Eighth Circuit Court of Appeals, the Department of Corrections prevailed on all counts. And if you visit any of your correctional facilities throughout the state today, you will see women working in all positions through those facilities, and I think the facilities are much the better for it, and I think the administration would agree with that. In 1982, I became pregnant. My job was secure because in 1978, Congress passed the Pregnancy Discrimination Act, recognizing the right of women affected by pregnancy to be free from employment discrimination. In 1983, my first child was born. I took 3 days off work for childbirth to clean the house and mow the lawn before returning to work full-time. For the first 6 weeks, I brought my baby with me to work, but I had the personnel department remove 6 weeks of sick leave from my account because I didn't want anyone to complain that I wasn't giving full attention to the job while I had the baby with me in the office. In 1987, when my second child was born, I did the same thing. In 1993, Congress passed the Family and Medical Leave Act, allowing new parents to take up to 12 weeks of unpaid leave for the birth or adoption of a new child without being in jeopardy of losing their jobs. In 1991, I moved to the Office of the Attorney General to head the Civil Rights section. I was the only female section head in the office. In 1995, I was promoted to Deputy Attorney General for Criminal Matters. I was the first woman to serve as a Deputy Attorney General in Nebraska. Nationwide, women served as governors, congressional representatives, and senators long before they were elected as state attorneys general. Some speculate that voters had a difficult time accepting women in the authoritarian role of prosecutor. In 1985, the first woman was elected a state attorney general. She was a Roman Catholic nun who resigned from the Sisters of Mercy to defeat a 3-term incumbent. Her background may have given her a unique advantage among voters who attended Catholic schools because they understood that a nun could be very effective in law enforcement. In 2000, I filed for divorce. Although marriage is a contract of sorts, a divorce is very different from an action for breach of contract. You will recall that under Chief Justice Cook's common law, a woman had no right to property in a marriage. So divorce actions weren't handled as actions at law, in the courts of law. They were handled as actions in equity, in the equity courts, meaning that the woman threw herself on the mercy of the court to avoid becoming completely destitute. During my 7-year divorce, I discovered that the Social Security Administration had no idea what my name was, and I had difficulty transferring certain accounts like cable television into my own name without interrupting service, establishing a new account, and paying a new customer deposit. The history of payments I had made on accounts for 25 years didn't seem to matter because my name was not the first name listed on the accounts. Although I had worked full-time through the marriage and worked evenings and weekends on our real estate investments, I was surprised that so many men and women in the community, including newspaper reporters, assumed that the property in the marriage all belonged to my husband. In 2001, I moved to Omaha and took office as Nebraska's 20th District Court Judge. I'm the first and still the only female federal district court judge in Nebraska. Cases concerning Title VII, Title IX, the Equal Pay Act, the Pregnancy Discrimination Act, the Fair Housing Act, the Fair Credit Act, and the Equal Protection Clause of the United States Constitution all come through my court. Cases are tried to juries. The juries include women because in 1975, the Supreme Court said women cannot be excluded from serving on juries. Having women on juries and on the bench is important for many reasons, including the fact that their life experiences are somewhat different from those of men, and so they bring a different perspective to the resolution of disputes. I presided over one jury trial in which the plaintiff was a female sergeant with the Nebraska State Patrol. She'd applied many times for promotion to lieutenant but had been denied. Each time the decision was made by a panel consisting mostly of men who evaluated the applicants on such qualities as leadership, posture, tone of voice, and confidence. Each time a male applicant was selected based on those subjective criteria, even though the plaintiff may have had more education, more years of experience, or higher performance evaluations. The jury, which included women, submitted one question during its deliberations: how much money does the plaintiff want? Many cases in federal court are resolved on motions for summary judgment without the need for a trial. When there is no issue as to any material fact, I, as the judge, decide the case. In one case, my experience as a woman may have caused me to evaluate the merits of the case differently than a male judge. The case was filed by women employed by a railroad who were unhappy with the fact that the railroad's health insurance did not provide coverage for prescription contraceptives, even though it provided coverage for other prescription medications designed to prevent medical conditions that are less painful, less dangerous, or less debilitating than pregnancy. The union, which was 98% male, voted on what prescriptions would be covered under the plan. Not surprisingly, the plan provided coverage for prescription medications for erectile dysfunction and male pattern baldness, but not for birth control. I found that if the insurance plan provided coverage for prescription medications to prevent medical conditions that posed no greater threat to the health than did the condition of pregnancy, then the plan should also provide coverage for prescription medications to prevent pregnancy. A panel of judges on the Eighth Circuit disagreed by a vote of 2-1. I will add as a footnote that the railroad, after winning in the Eighth Circuit, immediately changed its policy and now does provide the prescription contraceptive medication. Nebraska is in the Eighth Circuit Court of Appeals, which also includes the Dakotas, Minnesota, Iowa, Missouri, and Arkansas. There are 17 judges on the Eighth Circuit, including senior judges. 1 is female. There are 6 judges on the Nebraska Court of Appeals. 1 is female. There are 7 judges on the Nebraska Supreme Court. 1 is female. There are 5 judges, including senior judges, on the U.S. District Court in Nebraska, and 1 is female. Once a week I go out to lunch. My weekly lunch is a Rotary meeting. I attend Rotary because in 1984, the U.S. Supreme Court held that service clubs like Lions, Kiwanis, Jaycees, and Rotary do not have a First Amendment right to exclude women. Shortly after I was nominated to the bench, Justice Sandra OConnor was in Lincoln, and we had an opportunity to visit. I had read her first book, The Lazy Bee, about her early years on the ranch in New Mexico and Arizona on the border, and we talked about our fathers. I told her that when I was very small, my father, who was overly optimistic and who liked me, said, "You could be the first woman justice on the U.S. Supreme Court." I told him, "I don't want to be the first woman anything. A lot of other women are going to be there long before I'm ready." She told me she felt exactly the same way. She never wanted to be the first woman on the U.S. Supreme Court. She wanted other women to get there first. In her second book, The Majesty of the Law, she said, I'll quote, "Society as a whole can benefit immeasurably from a climate in which all persons, regardless of gender, have the opportunity to earn respect, responsibility, advancement, and remuneration based on ability. Women are still engaged in a struggle against social attitudes that impose barriers to the achievement of this goal. In large part, success depends on changing minds at home, in the streets, and at the workplace, not just in legislatures and courts. Each and every one of us has a role to play in completing that task." Unquote. Studying the history of women's rights, recognizing how far we've come, and acknowledging how hard so many women and men struggled to reach the legal milestones that we now take for granted are the first steps in completing that task. But changing minds in the home and on the streets isn't easy. I'm optimistic that each generation will build on the legacy of the brave women and men who fought for equal opportunity for all. There is one trend that may merit discussion some other day. While the rate of divorce has stayed steady at 50%, the rate of marriage has been decreasing steadily over the last 20 years or so. The men who excel in their work and reach the top of their profession are generally married with children. More and more we're seeing that the women who are reaching the top of their profession are not married and often have no children. Now, with the 10 minutes that we have left, we're going to fasten our seatbelts and do the fast forward through the highlights of the outline of the progress that was made during the last 50 years. The 60s. The Equal Pay Act of 1963 bars discrimination in pay based on sex, but not discrimination in employment based on sex. The Civil Rights Act of 1964, Title VII, bars discrimination in employment based on sex. In 1965, the Supreme Court held the constitutional right of privacy includes the right of married women to use contraceptives. The 70s. In 1971, the Supreme Court held that the 14th Amendment's Equal Protection Clause applies to sex-based classifications. In 72, the Equal Employment Opportunity Act prohibits sex discrimination by state employers. In 72, the Supreme Court said single people have the right to have access to contraceptives under the Equal Protection Clause. In 1972, Title IX prohibits sex discrimination in educational programs receiving federal funding. In 73, the Supreme Court held a newspaper does not have a First Amendment right to publish want ads segregated by sex. In 73, the Supreme Court applied heightened scrutiny to sex-based classifications, but didn't really describe what it meant by heightened scrutiny at that time. In 74, the Equal Credit Opportunity Act prohibits lenders and credit agencies from discriminating on the basis of sex. Also in 74, the Fair Housing Act bars discrimination in housing, sales, and rentals based on sex. In 75, the Supreme Court said women cannot be excluded from serving on juries. In 76, the Supreme Court described what it meant by heightened scrutiny, that sex-based classifications must serve important governmental objectives and be substantially related to the achievement of those objectives. Then I have the date on this, 1978, the Pregnancy Discrimination Act bars discrimination in employment based on pregnancy. I included the beer here under heightened scrutiny as a reminder that many of these cases brought before the United States Supreme Court to establish the principles of equal protection and to eliminate discrimination on the basis of sex were brought on behalf of men who suffered sex discrimination. Now, they may have been brought by women's rights organizations, they may have been brought by women lawyers, but they chose cases that they thought the male judges would be able to understand. The beer represents 3.2 beer, and in one of the cases applying heightened scrutiny, the issue was women in the state could purchase 3.2 beer at age 18. Men had to wait until they were 21 years old. That was sex discrimination. Similarly, if men were barred from a nursing facility, a nursing college, that was discrimination. If the male spouses of females working in the military did not get the same benefits as female spouses of males working in the military, that was discrimination. Those were the kinds of cases that we were seeing brought in that era. In 1980, the EEOC guidelines prohibit sexual harassment in the workplace. 81, the Supreme Court said state laws designating the husband head and master are not valid. 82, the Supreme Court said state-supported nursing schools cannot exclude men. 84, law firms may not discriminate on the basis of sex when deciding who to promote to partnership. 84, the Supreme Court said business and service clubs don't have a First Amendment right to exclude women. 93, the Family Medical Leave Act allowed parents to take up to 12 weeks of unpaid leave. 1996, separate but equal education for women is not equal. Sandra Day O'Connor, Ruth Bader Ginsburg, New Millennium. In the New Millennium, Congress passed the Economic Growth and Tax Relief Reconciliation Act of 2001 that addressed a marriage penalty affecting two-income households that basically punished the women for working. In 2009, the Fair Pay Restoration Act was adopted and came into effect in the New Millennium. It applied a statute of limitations to begin anew with each discriminatory paycheck. The Hate Crimes Prevention Act of 2009 broadened federal jurisdiction to include gender-based crimes. Justice Sotomayor, Justice Kagan, and then what we may see in the future. I've listed a few things that could be on the horizon. I don't know, and I don't take any position on them, because one thing I don't do as a federal judge is take any position on legislation. And then our final slide takes us all the way back. We turn the clock all the way back to 195 BCE when Cato the Elder was the consul of the Roman Republic. And in that year, another fellow was born. His name was Terence. He was a Roman slave brought to Rome from Africa, and he became the most famous playwright in the Roman Republic. He is most well known for this statement: "I am human. Nothing that is human is alien to me." And with that uplifting comment from millennia ago, I will now close with my thanks. And if we have a few minutes left, I will be happy to take questions if I can answer them. Questions? Yes, ma'am.
Thank you for putting that recent historical perspective on this. It's difficult. I dare say all of us in the room have lived through these changes in law, and it's difficult sometimes to tell younger women, this is very new. This is very new. It was very recently that women achieved these rights. I just had one small question. When you said that the 19th Amendment did not give women the right to vote, it recognized, was it then the ratification by the states that gave the right to vote?
And I'm using semantics here, really. When I say it didn't give women the right, the women had the right. If you look at the language, it says that the right to vote will not be abridged based on sex. So it recognizes the right exists. The right always existed. It was abridged. And now that right is no longer going to be abridged. And I would draw the analogy to the 13th Amendment that abolished slavery. It didn't say, we have decided to give African Americans the right to be free, which they didn't have before. It said, no, that right existed, and that right's not going to be abridged any longer by any government. Well, thank you all very much. It's been a pleasure and an honor to be with you here today, and I think we are just about to the end of our hour. So go in peace. Thank you.